So, welcome to Habeas Corpus, Who Controls the Body, the revised 2025 edition. As the advert that went out said, it is almost 10 years since I first gave this talk. And that means that there are almost 10 years worth of newly qualified lawyers out there who have never heard this talk. There was also a request, very nicely phrased, by Gino Balistracchi from Ashton's, who said, please would I do it remotely if I wasn't prepared to travel to Norfolk to do it in person. So I decided that the time had come to do a one-off revisit of my original seminar. And it's called a Wine and Wisdom Seminar, because that's what these talks originally were. Wine and wisdom. We met in the days before Zoom, the days before Teams. We would meet to do these talks, and we would meet in a room and we would drink wine and I would impart wisdom. I don't know how many of you out there with your blank cameras have decided that 5 o'clock on a Monday is an ideal time to start drinking wine, but it is clearly an ideal time to impart some wisdom. So without further ado, I am going to start. Habeas corpus, who controls the body? And I will start with some of the myriad ways in which a body can be dealt with after death. Pets or other animals can be stuffed, some more successfully than others. That is what you get if you Google badly taxidermied cats, by the way. Humans, however, cannot be stuffed. So if somebody comes into your office and says that they need to be granted possession of a body for the purposes of stuffing grandma to keep her in the front room, that is going to be a very short conversation. However, if they tell you that they would like possession of the body so that they can take it on a road trip, that is fine. Because prior to burial, a body can be moved anywhere in England or Wales without charge or without permission and without using a coffin, provided that the work of the coroner is not obstructed. However, permission of the coroner is required if you want to take the body out of England and Wales. And I also rather suspect if you want to take them on an aeroplane, you are going to need a coffin. However, bodies are not classed as property. So if you take your body on a road trip and somebody wants it back, you cannot be subject to property offences such as bodies being seized or stolen because they're not classed as property. However, the personal representative does have a duty at common law to arrange for the proper disposal of the body. So an executor appointed by will or the person entitled to less of administration can obtain an injunction to secure delivery of the body for that purpose. If there is no executor, there is nobody entitled under intestacy, then the person with the duty to deal with the body falls upon the local authority, the coroner, the hospital, or the householder where the deceased died. Yes, that is correct. If a person with no next of kin dies intestate in your house, under your roof, you have a common law duty to ensure that that body is disposed of. However, this obligation stems from a case from 1840, so I am fairly confident that today you would be able to make the local authority accept responsibility if you don't want it. Alternatively, a householder, in inverted commas, may wish to rely upon that duty, as one of the cases I talk about later will show you. So those are the people who can call for the body so it can be properly disposed of. But what do we mean by proper disposal of a body? Well, that depends. So let's start with the more common one. And I'm going to start clearly with burial. Usually in a cemetery, a local authority cemetery or one attached to a church. But that doesn't have to be the case. There is actually no general prohibition upon burying your body or of a loved one in private land. Provided, of course, that you have permission of the landowner, who you would imagine would be a family member of the deceased, that the deeds of land do not expressly forbid this. Now, next time you all get hold of an office copy, imagine you're going to start checking that. And I can tell you, it is far more likely that your office copy will tell you that you are forbidden from keeping chickens than it does from saying that you cannot bury your wife in the back garden. The third condition is that the burial will not contaminate water sources. To that list, I would also add that the would-be burier thinks very carefully about the effect that the existence of a buried body will have upon the price of property when the time comes to sell. Although if you have a testator who has a particular desire to ensure that his or her property is never sold, expressing a clause in the will, inserting a clause in the will even, expressing a desire to be buried in the garden with an enormous headstone advertising that fact may help to achieve this aim. And that is because whilst you are at liberty to drive around your deceased body, once that body has been buried, it must not be disturbed without permission. And I suspect that is something that the conveyancing department is not likely to come across very often. After burial, we have cremation. Again, usually in a crematorium. But as with burials, there is scope to think outside the box. In 2005, David Wrigglesworth appeared at Leeds Crown Court in relation to benefit fraud relating to his mother's pension book. He had continued to use her book after she had died, and that, of course, is fraudulent. But the relevant part of the case for the purposes of my talk is that His Honour Judge Stewart QC, in passing sentence, commented that the fact that Mr. Wrigglesworth had carried out a DIY cremation in his back garden was not in fact a breach of the law, as he had not been causing a public nuisance. Those remarks were, however, obiter, and I'm not sure I would necessarily rely upon the remarks of a criminal sentencing judge some 20-odd years ago when advising your clients. So if you don't fancy burial, you don't fancy cremation, what about embalming? And yes, there he is. And because this is a remote hearing, I have given him a fig leaf. That's on the basis that I've got no idea who's going to be watching this right now. I've got no idea how many of you are at home and might be influenced by small people coming in asking when dinner is going to be ready, or indeed someone might be watching this on replay with their breakfast. So I've given him a fig leaf for today's purposes. If you come and see any of my talks in person, he's there without his fig leaf. And this is my favourite bit of the seminar, because you may not think of embalming as a proper disposal. But in 2002, a coroner ruled that the artist Robert Lenkovich, and later his estate, had the right to continued possession of the embalmed body of the tramp named Diogenes, this being Diogenes that you can see on the screen. And Diogenes had been found in a drawer in the artist's studio after his death. In my head, I'm picturing one of those little drawers that have got paper in it that you used to have in your art studio at school, but I imagine this must have been quite a big drawer, quite deep. Mr. Lenkovich, during his lifetime, had a penchant for drawing vagrants, and he had struck up a friendship with one particular chap whom he named Diogenes. And for those of you who are of a classical bent, or who, like me, are indeed married to a classicist, the original Diogenes was a Greek philosopher and one of the founders of Cynic philosophy. He made a virtue out of poverty and often slept in a large ceramic jar in the marketplace. And Mr. Lenkovich named this particular tramp Diogenes. And when Diogenes died, he gifted his body to Mr. Lenkovich by will, and Mr. Lenkovich had the body embalmed. It appears he managed to keep hold of that body by that old favourite method of strictly telling the truth. The council, acting on a tip-off, came by searching for the body shortly after his death, and they didn't find it. So when they asked Mr. Lenkovich, have you buried or cremated the body? Mr. Lenkovich answered, I certainly haven't buried it. Nobody asked him any further. The council went on its way, happy in the assumption that the body had indeed been cremated. But it wasn't. It was embalmed and was later actually displayed as part of an art exhibition. However, another use for a body, embalmed or otherwise, is donation, either to medical science or for use by medical students. And that second slide of Doogie Howser MD is for those of you over a particular age. Everybody else can just Google it. It's the sort of thing we used to watch when we came home from school a long, long time ago. Now, if you or a loved one is due for surgery, it is generally a comfort to know that your doctor has practiced on a body before being let loose on you. This is a perfectly legal and some might say altruistic method of disposing of a body. However, in my second year at university, I shared a house with medical students. And the second year was when they got their bodies. They got one body between two people. And having shared a house with a few medics, I'm not utterly convinced that leaving my body to medical students is how I would like to end up. But it's all about personal preference, both of the deceased and of the family and the loved ones left behind, which is also something we will see when we come to consider the way the court resolves disputes about bodies. Religious beliefs can also be very relevant, as can culture. And if your client is from Tibet, you may be asked to consider a Tibetan sky burial. Now, the internet, that well-known source of genuine authenticated facts, states that 80% of Tibetans opt for a sky burial. And figures from the Tibet Regional Civil Affairs Department are said to show that Tibet has 1,075 sky burial sites and about 100 people to conduct the rituals. I imagine you know the basics. There is a strong emphasis on the circle of life. And my notes say, pause briefly while you all mentally sing Elton John / The Lion King. There you go. Strong emphasis on the circle of life and a belief that the spirit of the dead leaves the body at the moment of death. It therefore makes sense that the now redundant body is used to feed vultures. However, what I didn't know, and what I discovered in the course of researching this particular talk all those years ago, is that the bodies are first dissected and broken up by trained professionals. And some of the pictures you can find while Googling sky burial are particularly gruesome. So you should be pleased that I chose this relatively benign one. I would, however, point out that this particular method of disposing of a body is not terribly suitable for England and Wales due to a serious shortage of vultures. Being consumed by pigeon is simply not the same. Sky burial is based to a large extent upon a belief in life after death by reincarnation. Cryogenics is based largely on the belief or hope, depending on the way you look at it, that science in the future may be able to cure disease and reanimate the dead to provide that cure. And this belief in cryogenics led to the unbelievably sad case of JS, which was widely reported at the end of 2016. And JS was a 14-year-old girl who was terminally ill. She had clearly articulated her wishes, and those wishes were that her body would be cryopreserved after her death, and that her father, from whom she was estranged, should not be allowed to view her body after her passing. Her mother supported her wishes. Her father, at least initially, did not. Now, because she was 14, she was a minor. Minors can't make wills. If you can't make a will, you can't appoint an executor. And as her parents, both her mum and her father were equally entitled to apply for letters of administration. Now, the method by which a body is cryopreserved means that procedures have to be put in place prior to death, and the body must be prepared within a very short time of death, ideally within minutes and at most within hours, otherwise it won't work. So JS's family were not in the position of being able to wait for death, then go to court to argue about who should have the right to control the body, and so the court was asked to determine the matter in advance of JS's death, whilst JS, of course, was still alive. Now, obviously, this particular case scenario isn't going to occur in the case of an adult of sound mind, because that adult could simply make a will, express their wishes, and appoint a like-minded executor who they could say is going to carry out their wishes. But of course, you might get it where you obviously have a minor and where the executor is not a family member, and there are family members with very strong feelings who may be likely to lodge an injunction with the court upon death, which could result in that very tight window being lost. And the case of JS was heard by Jackson J. In reaching his decision, he made it very clear not only what the case was about, but also what it was not about. It was not about endorsing or approving cryopreservation. And in fact, if you read the judgment, I think reading between the lines, I'd say that he's not a massive fan. And it's not about ordering that her body be cryopreserved. What the court was doing in circumstances where JS could not act on her own behalf because she couldn't make a will, and where it was not possible to wait until after death, like it usually would, was providing a means by which the uncertainty about what would happen after her death could be resolved so far as possible. And that's because a court doesn't usually order what will actually happen to the body. It doesn't normally say, well, yes, Mr. X, you should be cremated. Ms. Y, it is your turn to be embalmed. What they do is they select the person best placed to make the necessary decisions after death, which in JS's case was held to be her mother. So the court made an injunction preventing the father from applying for letters of administration, making or attempting to make arrangements for the disposal of JS's body, and interfering with the arrangements made by mum with respect to the disposal of her body. He also made a prospective order under section 116 of the Senior Courts Act 1981, alternatively under the inherent jurisdiction of the High Court. And that order was to take effect upon JS's death, appointing the mother as the sole administrator in place of the mother and father jointly, and specifying that the mother would have the right to make arrangements as to the disposal of the body and to decide who should be permitted to view that body. So in a nutshell, the takeaway from this case is that the role of the court is not to give directions as to the disposal of the body, but to resolve disagreements about who may make arrangements for the same, and in some circumstances to actually make that decision before actual death. Now, looking in a bit more detail about how this happens, if you were listening, paying close attention, and you've got over the trauma of both Diogenes and the vultures, you will recall that I mentioned that Jackson J had made his order either under section 116 of the Senior Courts Act or under the inherent jurisdiction of the High Court. And section 116 provides the mechanism by which the court can pass over prior claims to the grant. We can see it there. You all know it, I'm sure. If by reason of any special circumstances it appears to the High Court to be necessary or expedient to appoint as administrator some person other than the person who, but for this section, would in accordance with probate rules have been entitled to the grant, the court may in its discretion appoint as administrator such person as it thinks expedient. And Jackson said that where, as in the case of JS, there is more than one person entitled to a grant of administration, section 116 allows the court to substitute one for both. However, he did say, if I'm wrong about that, then I can get the same result by using the inherent jurisdiction. Therefore, he made the order either under section 116 or the inherent jurisdiction. Now, some 9 months before JS had come out, Jonathan Klein, now his Honour Judge Klein, sitting locally in Leeds, had had some misgivings about the use of section 116 in the case of Anstey and Mundell. And in this particular case, a dispute arose between the 3 daughters and a niece of the deceased Mr. Carty. 2 daughters, Valerie and Stephanie, wanted Mr. Carty to be buried in England. The 3rd daughter and a niece, Sonia and Cynthia, wanted the body to be buried in Jamaica, which is where Mr. Carty had been born and where he had grown up. There was a will which appointed Valerie and Cynthia, so that's one from each side, as executrixes, and which said that Mr. Carty wanted to be buried next to his mother in Jamaica. One of the daughters, Valerie, disputed the will on the grounds of testamentary capacity, undue influence, and knowledge and approval, and also suggested that there may have been a later will. Now, what Judge Klein said in his judgment quite properly, or rather what he said was that quite properly, Valerie didn't ask the court to determine validity at the hearing over who should control the body, but it was clearly of relevance that in the event that there was no valid will, the 3 daughters were the persons equally entitled to a grant of intestacy, and of course the daughters were split 2 to 1 about where he should be buried. So in those circumstances, the court was being asked to grant letters of administration under section 116, with that grant being limited to the disposal of the body of Mr. Carty. Once he's buried, and we've dealt with that, then they would argue about who should inherit and which will should prevail and all the rest of it. But for the purposes of the hearing in front of Judge Klein, it was simply the issue of who should control the body for the purposes of disposal. Now, Jonathan Klein's issue with section 116 was this. Section 116, he said, gives the power to the court to pass over a person who would otherwise be entitled. He said, note the words in section 116, appoint as administrator some person other than the person who but for this section would have been entitled. Now, we've all been there. We've all used section 116. You've got your parties fighting over the validity of will, over who should administer the estate. In the meantime, you've got an estate that's increasingly getting debts. You've got a property that needs to be sold. You've got a business perhaps that needs to be run. So everybody gets together and says, okay, fine. While we're fighting, we'll go and appoint Mrs. X, who's an independent solicitor, to administer the estate so that we don't have any more losses. And that's what the court does. It does it under section 116, appoints an agreed or independent third party. They administer the estate on a limited basis for the duration of the litigation. Usually, that third party is somebody who doesn't have any rights under normal circumstances to themselves to have the grant, so a solicitor, an accountant, someone like that. And their appointment comes from section 116. But in this particular case, Mr. Carty's case, all four parties arguably had an entitlement to the grant. Valerie and Cynthia, that's the niece and one of the daughters, had a right by virtue of being named under the will as executors. And Valerie, Stephanie and Sonia, the three daughters, were entitled under intestacy in the event that the will was deemed to be invalid. And as Judge Klein pointed out, he wasn't being asked to pass over an entitled person. So he wasn't being asked to appoint some person who wouldn't normally be entitled. He was being asked to select which of those entitled persons should be given the grant. And he wasn't happy about that at all. I personally don't have a particularly big issue with the wording of 116. I think it is actually exactly what the court is being asked to do, to pass over the people who are entitled until you are left with one. And it just so happens that that person is also entitled. But of course, I say that with the benefit of having read JS, where Jackson J said basically the same thing. And I've written a book about it and I've read lots of cases about it. So I obviously have an advantage over Judge Klein. And also we're now in 2025 and not back in 2006 or whatever that was. But because Judge Klein had concerns about section 116, he preferred to base his decision on the inherent jurisdiction of the court. And he noted that for the avoidance of doubt, he would have reached the same conclusion in any event. So your takeaway from Anstey and Mundell is, if you are taking this to court, plead both. But what was the decision? Was it England? Was it Jamaica? And that decision is where the difficulty in these particular cases can be seen. Because with so many probate and inheritance cases, the law itself is relatively straightforward. It's unlikely to be a source of dispute. You know, this is section 116. The court has the power to do it. The difficulty is, how will the court exercise the discretion that everybody accepts that it has? And the difficulty that you have, that I have, that the court has, is that like many probate inheritance cases, the reported cases, all the cases I've ever done, and in fact all the cases you will come across, are very fact specific. And they all involve parties who have very strong feelings about what should happen to their loved one. This isn't someone who is thinking, oh, well, actually, once upon a time, I was interested in this, you know, maybe they're going to get some money. People fighting over bodies are really invested in what happens. And where you're dealing with a body like this, the death is usually, well, hopefully, very recent. So not only are you dealing with people who have strong feelings, they are very recently bereaved, and time is of the essence. In the case of Anstey, Judge Klein made specific reference to the fact that he considered determination of the dispute to be somewhat urgent, as Mr. Carty had died over 6 weeks previously. Now, think about what that means in terms of your work. 6 weeks from death to hearing. Lawyers were probably not even consulted until sometime after death, so you've got less than 6 weeks. You might also be faced with a situation where the cremation or burial is booked for the following week or even the following day. I have been there. I have been in court on a Friday afternoon arguing for an injunction to prevent a burial on the following Tuesday. I was making submissions, my parent was making submissions, the judge was asking questions, we were right in the middle of it, and the judge got an email and he said, no, stop, you don't need to go any further now. This dispute can be heard in full on Monday. And decision will be given at 9 a.m. on Tuesday morning, because the funeral was due to start at 11 a.m. on Tuesday morning. As you might imagine, that was quite a long and stressful weekend, leaving court at 3 o'clock on a Friday to come back for 10 o'clock Monday morning. And in the meantime, over that weekend, we had to draft witness statements, we had to get skeleton arguments, we had to do bundles, the works. We did it, got judgment at 9 o'clock, and the funeral, in fact, did take place at 11 a.m. But as I said, it was quite a long and stressful weekend. Anyone who had any plans had to put them on hold. Anyway, going back to Anstey, Judge Klein decided to follow the judgment of Sonia Proudman QC in Hartshorn and Gardner, and said that the factors to be considered were the wishes of the deceased, the reasonable requirements and wishes of the family who were left behind to grieve, the location with which the deceased was most closely connected, and perhaps the most important, that the body be disposed of with all proper respect and decency, and if possible, without further delay. And clearly each of those factors will have to be considered in each case. And when you read the later cases on from Anstey Mundell, they all say the same. This is the criteria the court will apply when deciding these cases. But remembering, of course, that each of these cases are fact specific, it is still worth looking at how this played out in practice in the case of Anstey. So looking at the deceased's wishes, 2 of the parties asserted that he wanted to be buried in Jamaica, 2 said he wanted to be buried in England. Judge Klein noted at the beginning of his judgment that he accepted that all parties had adopted their particular stance because they genuinely believed that those were the wishes of the deceased. There was a hearing, there was cross-examination of the party, cross-examination of their witnesses, and the judge came to the conclusion that he had wanted to be buried in Jamaica. And it's expressly noted in the judgment that that was based primarily upon the evidence heard in court. He, in fact, placed very little weight on the expression of wishes in the will. The family requirements and wishes, the family was split. 3 members called for England and 9 apparently wanted to see him buried in Jamaica. But the judge said it's not a numbers game. We need to consider who those family members are and the nature of their relationship with the deceased. And in this case, 2 out of Mr. McCarthy's 3 daughters wanted England, and the court was urged to attach particular weight to these wishes precisely because they were Mr. Carty's children. However, the Judge Klein found again on the facts of this particular case, after hearing the evidence, that apart from his daughter Valerie, whose wishes were accorded additional weight because of her close relationship with her father, he was equally close to other members of his extended family as he was to his other 2 daughters. So again, you can see how these cases are very fact specific. The location with which he was most closely connected. It was held that he was neither more closely connected with Jamaica or England, or turning it on its head, equally closely connected with both. And then finally, who is most likely to carry out the obligation to dispose of the body with respect to the deceased with due expedition? The judge found that all parties were likely to carry out the task with due respect, but in this case it was necessary to consider the practicalities of a burial in Jamaica as against a burial in England, the body being in England, and also the financing of the same. Now, the conclusion reached by Mr. Carty was, the conclusion reached by Judge Klein in relation to Mr. Carty was that he should be buried in, drumroll, Jamaica. And a particularly weighty factor being that that had been held to be his wish. So what the judge said is he was going to give the limited grant to the niece Cynthia, although he did say that he would insert into the order a provision that would allow the parties to return to court in the event that the burial in Jamaica hadn't been carried out by a specific date, and because he was concerned that it was very essential that this body be buried. Having reached a conclusion, the court then had to determine the issue of costs. And this is the part where you should sit up and pay attention, because it was held in Anstey that this was hostile litigation of the normal sort. And as such, costs followed the event, and the defendants were awarded their costs against the claimants, which in this case were assessed in the sum of £6,000. And the reason I suggested you pay attention is because I still receive briefs on a fairly regular basis where everyone's just been told, don't worry, in a case like this, you're arguing over the disposal of the body, the costs have just come from the estate. No, they don't. I have done several of these cases, and in all of them, costs have followed the event. But there was a case relatively recently of Patel and Patel. And yes, I do get it's a 2025 case. This is not something that was mentioned in my talk 10 years ago, but I do feel that in the interest of bringing you a full picture, it has been necessary to update this talk somewhat. But in this case of Patel and Patel, the court held that the cost of both parties should come from the estate on the basis that it was the failure of the deceased to provide his wishes that was causative of the dispute. Now, when you read that case, or rather when I read that case, I'm not utterly convinced by that reasoning, and you can hear why in this very exciting podcast, a Park Lane Cladden podcast, a closer look at burial disputes, which you will find on the Chamber's website, where I discuss this case and indeed other bits of dead people and their bodies with Marisa and Kate from Chambers. But that's how it was determined in the case of Anstey and Mundell. Now, bearing in mind that I have said that all these cases are fact sensitive, it's still helpful to get a short overview of some of the other reported cases, just so you can see how they play out in practice. Case of Scotching and Birch from 2008. The claimant was the father of the deceased, who was a child named Jay, and the first defendant was his mother. Now, this again is a tragic case. I mean, all cases involving child deaths are tragic, but in this particular case, the parents were separated, and at the time of the hearing, the defendant mother was on remand for killing Jay. Her plea of guilty to manslaughter on the grounds of diminished responsibility had been rejected by the CPS, and so she was on remand. And the dispute between the parties was in relation to the location of the funeral and subsequent burial, because these parties lived in different parts of the country. Claimant father wanted Jay to be buried near where he had lived. The defendant mother wanted him to be buried near where she lived and where her 3 minor children from a previous marriage, and therefore the half siblings of the deceased and defendants in their own right, still lived. And the interesting twist in this particular case is that the court accepted that because the mother had unlawfully killed her son, she in fact no longer had any interest in his estate as a matter of public policy, the rule of forfeiture. Therefore, she was not a person entitled to a grant under the non-contentious probate rules. But the minor children argued that they had Article 8 convention rights, that's private and family life, which had to be considered. The court said that both the children and the father had put forward compelling arguments as to why Jay should be buried in their chosen location. And the judge in that case, Patton J, noted that it is almost impossible to weigh up and decide between these various factors in purely qualitative terms, as would have been necessary under section 116. So basically, either would have worked. However, he said, in this case, the court is not called upon to make that decision because, as a matter of practicality, only the claimant has the right to apply for the grant, and therefore the grant should be issued to the claimant. In the case of Lewisham Hospital and Hamath, the claimant in this case was Lewisham Hospital, which was the hospital where the deceased had died almost 3 years prior to this decision. The first defendant was the executor under a disputed will, and the second to 13th defendants were either first or second cousins of the deceased. The first defendant sought cremation. The other 13 sought burial in the family plot. The claimant, being the hospital, just wanted authority to deal with the body, to get it out of their morgue, to clear out some space. Now, it's important to note in this case that the first defendant, who wanted the cremation, was a nurse at the care home where the deceased had resided before being admitted to hospital, and there was a significant dispute between him and the 13 family members over the validity of the will, which not only appointed the first defendant as executor, but also as the sole residuary and primary beneficiary. There were issues in relation to capacity, the validity of the will, a large number of checks which had been drawn in favour of the nurse prior to death. All of that was going on. And Mr. Justice Hart noted that the authorities established that an executor has in general the right to make arrangements for the disposal of the body. However, at common law, it is the duty of the householder under whose roof a person has died to make arrangements for the dignified and decent burial of the deceased. And on that basis, he felt he was able to give the right to bury to the claimant hospital, relying upon their rights as householder. So you see, it is worth knowing case law from 1840 after all. The question for the court was whether a claimant's duty could be discharged in circumstances where there is a bona fide dispute over the validity of the appointment of an executor, which was highly unlikely to be resolved in a reasonable period. So the court said, well, I don't know whether this was a valid will or not. I don't know whether this executor is a proper executor or whether it's someone who is going to be found actually to have no standing whatsoever because he's not a family member. He isn't entitled under intestacy. If the will goes, the executor goes. However, I do have a householder. I've got a hospital. He died under their roof, so I'm going to give it to the hospital. Probably helps as well that the hospital was planning on burying him and basically doing it in accordance with the family wishes. The case of Hamath was quoted in, or cited, sorry, in the case of Lang and John Poyser, where the Court of Appeal did not interfere with the first instance decision of His Honour Judge Hodge, who had refused an injunction by the appellant to prevent the respondent's solicitors, who had been named in the will, from cremating his mother. Mother had died, left a will stating that she wanted to be cremated. The son had disputed the validity of the will. The judge refused the injunction. He said the court wasn't in a position to finally adjudicate it upon the validity of the will or on whether the deceased wanted to be buried or cremated. However, on the evidence, it could not be said that the challenge to the validity of the will was certain to succeed, and therefore the grant was issued to the solicitors. I rather suspect, reading between the lines, there was no way that challenge was going to succeed, and therefore the executors were always going to be the executors. And finally, again, another addition to my original talk, the case of Reid and Harian from 2024. And in this case, the deceased was 18 years old when he took his own life. He had died unmarried, without children and intestate, so the persons with the right to call for his body were his parents. They were separated, they didn't enjoy a good relationship, they'd been involved in protracted family dispute when he was younger. The time of his death, the deceased was experiencing mental health difficulties, was living in assisted living, so not living with either parent, but he was enjoying a close relationship with his father and had had no direct contact with his mother since 2016, so 8 years previously. The parties were agreed as to the location of the funeral, they were agreed about cremation, but they could not agree as to the identity of the funeral director or what should happen to the ashes. The father wanted the ashes scattering on Dartmoor. The mother wanted the ashes to be divided between the parents so she could inter her half in her family grave. The father said that division of the ashes was morbid, it was disrespectful, and it was noted in the judgment that he plainly felt very strongly about this. The parties agreed that they couldn't decide about the funeral, so they were just going to have 2 separate funerals, and the judge said that was a good idea. Having reviewed a number of cases, Chief Master Schumann concluded that body disputes are highly fact-sensitive, but in considering the wishes of the deceased, their family and friends, and the location with which he was most closely connected, the overarching principle is that there should be a decent and respectful disposal of the body without undue delay. You're back to the factors that I talked about previously when we were doing the case of Carty in Anstey and Mundell. Having heard evidence from the parents and various witness statements from various people, the conclusion reached by the judge was that she didn't know what the deceased's wishes were, but that he had a close connection and a feeling of peace when he was at Dartmoor. So she ordered letters of administration dealing with the body should be given to the father. The practical effect of that case, I'm not dealing with issues, this isn't an ashes case, but the practical effect of that order was that the ashes would not be split, although the Master made no specific comment on this particular issue, and she also didn't make any comment on the case of Fessy and Whitmore, to which she had been referred, and Judge Boggis in that case rejected splitting the ashes of a 12-year-old child between his parents, declaring the submission as wholly inappropriate. The takeaway, I think, from the roundup of those particular cases and from my experience in dealing with these cases is that where only one party has a right to the grant, the court can and often generally will decide it upon that basis. These are very, very difficult cases to decide. So if you have one party who has a right and another party who does not have a right at all, then that is obviously an easier way for the court to deal with it. But where you have 2 parties with equal rights and differing opinions, it is going to be a matter of discretion, it's going to be a matter of evidence, and you are just going to have to wait and see what comes out and what the judge decides. So that's a quick roundup of the cases. But before my big finale, because I'm going to finish before 6 o'clock, this would not be a Nikki talk without at least a plug of one of my books. And the book I've chosen to advertise to you today is, funnily enough, A Practical Guide to the Law in Relation to Control of the Body After Death. Available on Amazon or via Law Brief directly. And actually, joking aside, when I originally gave this talk almost 10 years ago, this is the book that it led to, because I gave this talk to quite a lot of people, went around and gave it to lots of people, and I was contacted by Law Brief who said, actually, that's quite an interesting subject. There isn't any law on it. Can you write a book on it? So what this book is a more in-depth look at what we have been talking about today. It has far more law, more exciting subjects to argue about, such as ashes, disputes over burial plots. You won't believe the number of times people are buried in the wrong plot. And it does, however, I'm afraid, contain far fewer naked embalmed tramps and vultures than this talk. And in case you're wondering, though, the other book I could have told you about was A Practical Guide in relation to the law in relation to presumption of death and guardianship orders, which is, as you might imagine, about guardianship orders and presumption of death. But of course, the two link together because that's what happens when you haven't got a body. But back to the talk. Before I got sidetracked with the law and shamelessly advertising my books, I was talking about cryogenics. So I'm going to finish this talk with the tale of Ted Williams, who apparently is a famous baseball player in the States, or indeed was a famous baseball player in the States. Now, Mr. Williams' son, John Henry Williams, and the internet says that indeed is him, he was adamant that his father wanted to be cryogenically frozen so that he could be brought back to life in the future. Not only that, but he wanted the rest of his family to be frozen after their deaths as well, so that they could all be resurrected together. To this end, immediately after his death, Ted's body was flown to the Alcor Life Extension Foundation, where they promptly set about separating his head from his body, placing each into separate cryonic suspension. Don't know why they do that, but there you go, that's what they do. But the problem was that Ted had left a will in which he said he wanted to be cremated. And this dispute went to court. John Henry countered this will with a family pact relating to the family freezer, which was written on a cocktail napkin. And for those of you who are peering very closely at their screen now, that is not the cocktail napkin. That is a generic Google image of a cocktail napkin. Because, of course, when I originally wrote this talk and did these slides, AI didn't exist. So I couldn't ask AI to make, well, it probably did, but not on Google. So I couldn't ask AI to make me a relevant napkin. But yeah, so he countered the will with a cocktail napkin upon which this family pact was written. Now, I don't know the details of the court hearings. Google is not that advanced. But I do know that the napkin was upheld and Ted's body and head therefore remain in storage, presumably waiting for the day when science can not only cure the leukemia from which he died, but has also worked out how to reattach the head to the body from which it was severed. And it's at this point that the recording will end.